Hi, everyone, and welcome to the newest episode of AI and the Future of Law. I'm your co host, Jen Leonard, founder of Creative Lawyers, here as always with the fantastic Bridget McCormack, president and CEO of the American Arbitration Association. Hi, Bridget. How are you?
I'm great. It's good to see you. Happy to be here.
Great to see you as well. And we are here today on release week of the newest model from OpenAI, GPT-5. And we're going to talk all about that today in our What Just Happened segment, which is where we try to connect for our legal audience what is happening in the broader landscape. Before we dive into our main topic this week, where we will talk about a report from the Institute for the Advancement of the American Legal System, or IAALS for short. But we will kick off as we do every episode with our segment called AI Ahas, the things that we are using AI for in our personal or professional lives that we find particularly delightful or interesting that we're learning from. So, will you do the honors and kick us off this episode, Bridget? What have you been using AI for?
Bill, and I have to say, this gets like more and more complicated. I feel like every time we do this because I I have too many things to choose from. I'm not sure they're all interesting, but I do find, like I bet you do, that it's now just crept into so many parts of my life. And I was saying to you recently that I feel like lots of other people in my life are coming along. I've had like friends and family members ask for, tutorials recently. And once I give them the tutorials, they get, they have the experience of actually using it instead of hearing me talk about using it. And I think it's different. When on GPT-5 release date, I got a text early in the morning from my brother I had a couple of months ago given a tutorial, and he was like, GPT-5's out today. And I was like, yep, it is out today. So it's that's been kind of fun. But the one I want to talk about today is I've been using it to help me think about how to talk about, both in writing, because I'm like drafting something that I may or may not publish. I don't know. We'll see. And in presentations, the level of human error we tolerate in courts. And what prompted this, you won't be surprised, is those stories about the two different judges, and I think they were both in federal courts, doesn't really matter, that released opinions recently, like in the last few weeks, that had hallucinations in them. And they were clearly hallucinations. In both cases, the opinions were withdrawn, which is, of course, the right thing to do. And there's been so much backlash and pearl clutching and, lots of fretting across legal communities about like, oh gosh, now we have judges using AI improperly. And that's all fine. But it has like steam coming out of my ears because of the as opposed to what question, right? I don't, to quote Andy Perlman, like if we were considering those examples against a justice system where there was no error, then I want to pile on. I want to pile on about like how we need to make sure courts have resources and training and can use AI correctly. And I actually think all those things are true. I want them to have resources and tools and technology, frankly, to help them do their job better. But as somebody who practiced in courts for a long time and worked in courts for a long time, the human error that we tolerate is so significant. But it's not good enough to just say that. I wanted to figure out how to say it with some, robustness for different audiences. So first I said, like, help me with the numbers. Like, how could we measure it? And GPT-5, like, went way too deep for me. I actually had to pull it back. I was like, okay, that's too many numbers. Like it was literally like coding different graphs and like you can use this graph in a slide and it shows the intersection. I was like, no, 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 no. Just do your best to like pick one jurisdiction, get the reversal rate. Like let's start with the reversal rate in appellate reversals of trial court decisions in federal court. I picked the federal court that Michigan cases are appealed to, the Sixth Circuit, and then do the same in the Michigan appellate courts. And so and then let's think about whether that number is like a fair place to start. And so that number, by the way, is in the Sixth Circuit last year. The reversal rate was about 5.6% if you average the criminal and civil cases. The civil ones were actually 10%. The Michigan Court of Appeals, 21% of cases were reversed and 11% gave partial relief. Like that's a stunning number of cases where we are saying GPT-5 went and did all the data crunching for me, so I just have the numbers, which is really convenient. And what I haven't done yet, but I still have it like thinking about how to do it, is I wanted to now look at the number of opinions where the court did not reverse, but it didn't do so because it was tolerating harmless error. Because in an awful lot of cases, we affirm a trial court decision, even though there's error, but we explicitly tolerate harmless error. And I want to sort of add those numbers to the mix next, and it's still working on that. I then asked it to think about how we would layer on exonerations. Exonerations are cases where after a case has been fully affirmed throughout a court process, later we learn that there was a mistake, an error that meant that the wrong person had been convicted, or somebody who hadn't committed a crime had been convicted. So that's yet another category of cases where even that appellate court reversal rate is undercounting, right? Then I asked it to think about how to layer on the number of cases that never get appealed. Because as you know, and we talk about all the time, most people in civil cases can't afford lawyers. So they might find a way to navigate their trial court case. Probably not that well, because we speak this other weird language in courts. They almost never can figure out how to appeal those cases if they don't like the result. So it's a really small number of only lawyered cases that even make it there. So this floor, this rate of error that we tolerate, is a very squishy, soft floor. And I had it like just create a bunch of different things, some slides, some talking points, some ways to talk about it in writing, talk about it to different audiences. And it really helped me like think about how to talk about this in the future. I have not inserted myself yet into this conversation, but as you can tell, I'm a little worked up about it and a little bit ready to. And I now have lots of data and ways to think about talking about it at my disposal. And that was way too long for an aha, and I apologize. How about you? What was your aha?
Gosh, I really do not enjoy following your Bridget. That's incredible. It's also making me think of a presentation you and I did earlier this year with Darth Vaughn, where he was interested in gathering data on the number of times when lawyers cite, this is a different point, but the number of times lawyers cite cases for the inappropriate position or the incorrect position in an attempt to deceive courts. And, not that we tolerate that, but how many times that goes undetected. So there's all sorts of false statements in briefing before courts. And then, as you mentioned, just outright error in decisions made by courts, whether it ultimately affects the outcome of the case or it's overturned. That's super interesting. I'm laughing at your initial output from GPT-5 though, because some of the reviews compared it to like overworked assistant, or is that what it's over energetic assistant energy?
Yes,
Which was definitely what I was getting from it. Like, chill out.
I know. It's like, dude, take it down a notch. Yeah, we're talking to people who don't view statistics. Let's just like talk in basic numbers.
I struggled with my AI aha this week because mine was a little bit in the reverse direction. It was a little bit back to basics. I think it's a result of being challenged by a project that I'm working on in a way that's uncomfortable to me. So I have been trying to use different AI tools that I love to make the project easier for my brain because the activity's inefficient for my brain because it's challenging. And by trying to use all of those tools, in the end, I was just like finding new ways to spin my wheels and not making the project like high quality. And eventually I realized that I've just found all new tech infused ways to procrastinate. And what I ended up doing was I just sort of had to like slap myself on the wrist and shut down my laptop and take out a piece of paper and sit down and start writing with a pen from scratch using like my naked human brain to write longhand. And it made me think of, and again, I feel like we should have like a Pee Wee's Playhouse like sound every time we say Ethan Malick's name. He's like the word of the day.
We
But
should, yeah.
he had he had like a great one useful thing blog post about, and I think like the big takeaway was write first, think first, meet first, about all these tools are going to come out that make it really easy for us to shortcut a lot of the things that are painful for our brains to do because they're inefficient. But the inefficiency and the investment of energy is the actual point in getting a quality product.
Yeah.
And so that's what I learned about working on this project is I wasted a lot of time and energy trying to use AI to shortcut it when really I do ultimately want to use AI on this project, but it now is not the time to do that. The time to
Yeah.
do it is later when I've drafted it and I want to refine it and make it better. And I can already see how I'm going to do that, which is to get feedback on the writing, to find places where I can refer to different parts of the writing in other areas, because that's something I'm not really familiar with or skilled at. Like when you read a book and they say, like, remember back in chapter 3, we talked about this. Like, I feel like that takes either an editorial team or a skill set I don't have that I feel like the AI could help me with and other things, but this was not the way to do it. But I'm glad that I learned, and I hope that that will help me also teach other people as they're trying to learn how to use it.
Yeah, that's really interesting. I feel like I've had that experience a number of times where I jumped in too quickly and then I realized this is not helping. I need to step back and at least figure out what I think I'm building or creating in terms of a writing project or a memo or a strategic plan of sorts. You have to at least have done the initial thinking. I don't know what I read recently. Did you read this? I'm sure we're all reading all the same things, but that, the thing about AI is it's kind of middle to middle, not end to end. And like you really are still valuable at the front and the back, right? The back we know, like check your sites before you file the brief or check your sites before you deliver the opinion. But the front is also right, like just in framing and organizing and thinking about what it is that you're then going to get the middle to middle help with. And I think that's still true.
Yeah.
Maybe it won't be true like 5 years from now. I have no idea, but it definitely feels true now.
And I think, and again, I think Ethan's written about this and others have written about this too. I don't want to suggest he's the only person writing about this, but the research on learning and I mean, it's also logical if you think about it. You're not making a deep impression in your mind
Yeah.
if you're offloading things to AI. And there are lots of places where we can use AI for lots of different things. And that's what you and I talk about all the time. But if you're working on a project where your goal really is to learn about the content and develop new ideas and new connections, you want your brain to be deeply invested in that learning process. And I felt like I had been thoughtful in developing the outline and thinking it
Yeah.
through. And then I was like, okay, I'm ready to dive in with my buddy Claude and we're going to like workshop this together. And I don't know. It just was not working. I was like, I'm just going to have to come back to you, Claude. I just need to go back to my whiteboard and my mind mapping and my drafting the old fashioned way. So it's almost like my AI aha was my human brain sometimes is just needs to be by itself for a little while.
Yeah. We're not ready to replace it yet. That's because your brain is like super big and smart. So I get it. Yeah.
Well,
I love your
thank you,
brain.
Bridget. Oh, I love your brain. Thank you. Okay, so on to what just happened, because this is a big episode for people who are following different model releases, or if you're not following and you might have heard this in the ether, the big sort of model that we've been waiting for all year has been ChatGPT-5, lots of teasers, lots of hype and build up. So Bridget, what just happened?
We finally got ChatGPT 5 last Thursday, I think it was. We sort of knew it was coming. I mean, there was a lot of like sort of hints that it was coming, and then there was this announcement that they were going to have a press conference at 1 o'clock, and we got the press conference at 1 o'clock, and we got GPT 5, which is OpenAI's most advanced model yet, and it does a few things that are new. The first thing it does is auto routes between the fast thinking models and the deep thinking models. So there's GPT-5, GPT thinking, and then GPT Pro, which is research grade intelligence. So those are the three different models. And what it does is you put in a query and it decides which model it needs to answer it. And sometimes when it's figuring out that answer, we'll switch back and forth between those models to be able to give your query the right amount of attention. That's actually something that I've been like looking for wanting for a very long time. When my choices used to be, there were like 8 different models, and I would sometimes forget that I was in the quick model because the last thing I asked only needed the quick model, but then I asked it something else and I really needed a reasoning model, or vice versa. I was always like, oh, I wish it would just do that for me. And so now it does do that for me. And I personally like that. The thing that happened though was they rolled out GPT-5 for everybody, even free users got GPT-5, and the other models disappeared. So you no longer had access to 4.0 or O3 or whatever model you were using and liked before. And that caused a lot of backlash, and I'll turn to that in a second. But a little bit more, just some of the details about GPT-5. On the benchmarks and the legal benchmarks, the IAALS study, GPT-5 now is the top model, coming in just above Gemini 2.5 Pro, which is just above XAI's latest model. And it's got PhD level smarts. If you've read any of the press around it, it's especially good at medicine and science and math. I don't code, but they say it's a lot better at coding, and the reasoning is better, they claim, than O3. It has a very large context window, and it also is a little less sycophantic than 4.0. But at least that's the claim, and I think I've witnessed that myself. It's less likely to say, "Oh, what a brilliant question! You're so smart. Let's go dig into that together." Instead, it just kind of gets to
Like me, who tells you that after everything you say. But I genuinely believe that.
yeah.
I think you're brilliant.
Thanks. Thank you. Well, I'll ask you when I ask.
An older model, though.
And that actually, that actually works, I think, for me quite well. But as it turns out, not everybody loved this, and there was quite a backlash over the weekend. And I felt like Sam Altman and all of OpenAI were in crisis communication mode from basically Friday until, I don't know, maybe they still are. I'm not totally following. A lot of people really resented losing access to those models that they had really gotten used to, and some of that was sounded emotional. Like they ended up really liking the conversations they had with one of those previous models. Some of it is I know people who built specific GPTs on those previous models, and when there's a new model, those get they don't always work, right? And so it might have helped to have a little notice that we're transitioning these models, and so what you built might not work, and let's figure out a solution for that. And there was enough backlash that I think OpenAI actually reverted and now allows paid users to have access to 4.0. So I think the question is is there anything that this means differently for lawyers? And I'll be interested to hear what you have to say. I think the answer is no, although it is, it's better than any previous model on legal work and better reasoning work. And I, as always, have asked this model and the latest Gemini model and Claude some of the same legal questions just in the last week, and I do see significant difference in GPT-5. I really do. I think it's really doing more robust legal work. But it's not good enough to it's not good enough to not check it. Like you could have like the best 1L summer associate or best new associate in the world, you still wouldn't file something they wrote as a memo directly with a court without checking it. I mean, there's just a reason why lawyers have the training they have and are licensed to practice, and it's to be able to do some QC on that work. So I think you can think of it as a a great first start, but I still think lawyers need all the same safeguards that they needed with the previous models. But I don't know, what have been your experiences, and what advice do you have for lawyers in GPT-5?
For most lawyers, I would say don't worry about trying to keep pace with catching up with the newest model. All of the things that you and I advocate and teach remain the same. Experiment, share with your colleagues and others what you're learning, where the limitations are, where the benefits could be. And as you said, all of the ethical obligations to check the outputs over and over again, to not rely on anything that comes out of it, to treat it and supervise it as you would an inexperienced lawyer remain. As you noted, the VALS benchmark puts it at the top of the leaderboard of all the models out there, and it continues to improve. And I know that we have those slides that we use in presentations of the VALS benchmarking of human lawyers from back in March, putting human lawyers on a variety of benchmarking tests at around 70% accuracy. Just a quick look at those VALS benchmarking accuracy puts it at 84.6% on this benchmarking leaderboard here. I would want to dig into that data and see exactly what the tasks are and how that compares with those earlier lawyer benchmarking. But as you and I have said at different points, and to the point of your AI aha, as a species, we are not going to improve exponentially during our lifetimes, but these models will continue to get better and better and more reliable. So maybe to give myself a little grace with my AI, the challenge will be, where will we spend our time with our naked human brains and figure out where we still want to rely upon them as these models continue to get better and better. And I know that for firms that do have access to legal domain specific tools, I've seen posts across social media that certain tools that are built on top of these GPT models from OpenAI have already been upgraded to the GPT-5 models. And I did think it was interesting that in its press release on its website announcing GPT-5, OpenAI specifically called out legal as use cases that would become stronger as a result of this model upgrade. And they have relationships with different tools in our domain. So it's certainly something that they're aware of and looking to capitalize on.
Yeah, that's interesting. I mean, we'll follow this, I'm sure, and I bet we'll have more conversations about GPT-5 in many of our future episodes. But for now, I'm kind of 2 thumbs up on GPT-5, even though I've followed all of the backlash. But that takes us to our main topic, which is an interesting new report from IAALS, the Institute for the Advancement of the American Legal System. I should say that I am on the advisory board of IAALS, so I want to make that clear. That's not why we're talking about this report. In fact, I think you were the one that asked if we should talk about it, and I agreed. And your boyfriend works at Anthropic. No, I'm just kidding. You don't have a boyfriend.
That's an inside joke for anybody who listens to Hard Fork. We shout out to Kevin and Casey. I do not have a boyfriend. I'm happily married. But if I did, he would work at Anthropic.
He would work at Anthropic. Yeah. But I also released a new report on. I'm sorry, I couldn't help it. I also has this new report on the regulation of legal services, the unlicensed practice of law statutes, and how their intersection with AI is worth spending a little time on. And IALS did that, and they released this report. So why don't you tell us a little bit about what the report does?
Yeah, absolutely. So as you mentioned, Bridget, IALS does independent research and is an organization that is focused on trying to innovate and advance solutions to make the civil justice system more just. They're based at the University of Denver. And at the end of last year, they had a gathering focused on regulating the use of AI in consumer-facing technology. And what I really appreciate about IAALS' approach is it is trying to move us from a more lawyer-centric approach to regulation to a more consumer-facing approach to regulation. And the report talks about how important that is in an era of AI where the technology is moving so quickly, especially because, as you and I both know and talk about frequently, we can't overstate how grave the civil justice crisis in the US is. Most Americans and small businesses can't afford legal help. And you and I and the team at IALS and the people who contributed to this report really believe that this suite of technologies offers an unprecedented opportunity to try to put in the hands of those individuals and small businesses tools that allow them to help themselves access legal services. So the report digs into some tools that are already doing just that, like Courtroom 5, ZAF Legal, Roxanne, and Rentervention, and gives some nice use cases and case studies. It also talks about some states that are starting to use AI-powered chatbots to help self-represented litigants like Nevada and Arizona. It talks about all of the risks that lawyers are well aware of and the things that we're concerned about, hallucinations, biases, privacy concerns, those kinds of things. But it really takes a positive perspective, I think, and asks, how do we try to take this moment to expand access to legal services and also recognize, as the report does, that the public already turns to the internet before AI emerged onto the scene regularly for legal help because they don't have access to lawyers. And we can assume that they're already turning to AI, not only because ChatGPT is here and we don't yet have great data on ChatGPT usage for legal help, but also because Google now has AI summary overviews as part of its search results. So we know that people were using Google to search for legal help before, so they are necessarily using AI summaries. And the report points to some research that Margaret Hagan from Stanford presented during the gathering, showing that trust in AI is growing because of its affiliation with the big tech companies, especially Google, because the public trusts Google and internet searches generally. But that people trust human legal support before or over AI or technology generally, especially for more sensitive matters like domestic violence proceedings or divorce. So in family law contexts, criminal law contexts, things that have real human stakes. So the question that the group posed was, how do we take that tendency to trust human legal support and leverage it to play a positive role in helping to educate the public and, where appropriate, try to figure out what regulation might look like in an AI era, and maybe partner with technology providers, maybe create some soft regulation, but at the outset, really raise questions, important questions that we need to answer, gather data around how people are using AI. And so I view the report as really structuring a framework around those questions. And it sort of concluded with two different phases of a proposed solution. So phase one, it couched as soft power actions. And those actions included issuing best practice guidelines for developers, deployers, courts, and consumers, launching regulatory sandboxes so that we could test tools in a safe and monitored environment, which several states, Arizona, Minnesota, some others have already done, collecting more robust data on consumer outcomes, exploring partnerships with big tech companies to improve legal AI, and using prosecutorial discretion and safe harbor policies to give innovators breathing room. So this part, I think, is I would just highlight this because the tendency really is to, I'm editorializing here, be a little bit overly regulatory and go after anybody perceived to be engaged in the unauthorized practice of law without raising questions as to whom we're protecting, whether we're trying to protect
Yeah.
the lawyers or actually trying to expand legal services. And then the second phase of the recommendations, after we've sort of done that and learned more, raises the question of whether possible formal regulation would follow. And some of that formal regulation could include adjusting unauthorized practice of law and ethics rules if needed, creating certification systems for AI legal tools, developing a risk based regulation framework that would have different rules for high risk cases versus low risk cases, and pursuing uniformity across states. So, one thing that the report talks about that I also think is very problematic is just there are so many different jurisdictions and so many different UPL rules and frameworks, and tech is boundaryless and it's constantly changing. We just talked about GPT-5. Most groups I talk to don't even know what a reasoning model is, and the reasoning models are almost a year old. So, how can we be trying to apply all these different frameworks to a technology that's moving so quickly and doesn't respect the boundaries of different jurisdictions? So, that is essentially is my summary of what the report said. I think that centering the consumer and the public is the right approach. And it really offers up a lot of thoughtful questions and ways to think about the future. And curious your thoughts about the conversation it tees up for the profession, or anything that I
No, you didn't leave anything out. It's a great summary. I think it's a great contribution to a conversation that we, all need to be having. And it feels, obviously timely. There's like you said, people are using the technology, whether the law allows them to or not, they're doing it. So whatever the gray area is, I don't think there's a lot of people that are going to slow down and say, "Gosh, I can't afford a lawyer, but I'm not going to go get an answer from GPT-5, which I can do now on a free version, even though that might help me a lot in figuring out how to navigate this problem. It's just not going to work that way. So it does make sense for us to at least start having a conversation about whether some of our regulatory architecture is anachronistic. And if it is, maybe we want to think about, what it looks like to get from here to where we should be. And IAALS is just exactly the right, organization to start a large conversation about that. So I'm really glad to see it. It comes at a time when we're seeing other, like, I feel like there's just like other stuff happening that feels like it's bubbling up to like make this to allow this conversation to break through. So a number of state Supreme Courts recently have piled on to what seems to be a growing trend of allowing community justice workers, people other than lawyers, to provide some legal, information and advice and help in certain kinds of cases where the consumer is not going to have access to lawyers, and that makes a lot of sense. DC did it recently. In another jurisdiction that I now can't remember, but it brings the number of states that have done that, I think, into double digits, and so that feels like it's going in one direction. The Conference of Chief Justices released I don't know if it was a statement or something in support of that kind of program. And I think just yesterday at the annual meeting, the ABA passed a resolution encouraging states to create community justice worker programs, which really means encouraging state Supreme Courts, as state Supreme Courts are the ones that regulate the practice of law. And the National Center for State Courts has this partnership with TRI, and again, full disclosure, I am on the advisory committee of that project, and I chair the Access to Justice subcommittee, and we're also working on a paper about UPL and AI. So that'll probably be out within a few weeks as well. So those are some pretty important institutions to start saying, it's probably time that we rethink, this part of our regulation. I still always struggle with what the dance is between state legislatures and state Supreme Courts, right? Because UPL statutes are statutes. So what's to stop a legislature from just repealing that statute. Say the Pennsylvania legislature shows up for work on Monday and says, this UPL thing doesn't make sense anymore because, technology is now like doing all the kinds of things the statute says um, only licensed lawyers can do. So this one doesn't make sense. And they just repeal the statute. Does that give innovators in Pennsylvania like a big lane to figure out how to build products that really help consumers who need legal information and legal advice but can't afford lawyers? Maybe, but maybe not, right? Because the court, I think, ultimately has this inherent power to regulate the so-called practice of law, even in the absence of a statute. So it's still a gray area that needs our conversation. Like I feel like I'm happy. I'm really happy that spent the time on this and released a report that has like lots of practical solutions for courts, bar associations, innovators in jurisdictions that want to try and figure out how to get from here to where we need to be.
Absolutely. And I'm stating the obvious, and I know as you just referenced, there are so many different groups working on these solutions. It seems to me now the disconnect, and it was present when we had Google, but now it's sort of at a little bit further along the work products, like workflow timeline, is people will now be able to say to ChatGPT or Claude or whatever the model is, here's my legal issue.
Yeah.
And then increasingly the models will be able to do some basic research for them, help me figure out what next steps are. And then there's the gap between that and the actual activity that needs to take place. And
Yeah.
it seems like that is where the gap will exist. And I assume that is where the sort of legal justice workers and the sort of paraprofessionals that are different from lawyers come into play. Would that be the idea?
Yeah.
So if you have ChatGPT draft something for you that you could file with a court, there's now, and this goes back to the conversation we have with the Garfield AI founders in the UK, because they have an API connected with their courts where we still have a physically rooted system. You
Yeah.
still need an actual 3-dimensional human to help you through the system, which to me feels like a whole different problem to solve, where
Yeah.
you could have a more seamless solution if we had more of a tech API integration approach here, but you would still need humans.
Yeah, you still need humans. I think, again, I think it comes back to the middle to middle instead of end to end. Like, you probably, if it's available, if there is a community justice program or I've been trying to think of like what a like legal tech justice supervisor could be. I'm trying to think of like whole new categories of like legal workers and what it would be to train them and then, scale a business model that just had nothing to do with the traditional law firm business model. What would that look like? How could they make it work? Who might hire them? And you could imagine different community organizations thinking like, yeah, we'll take a subscription to your legal justice supervisor program. And if you have help both at the front end and helping the person frame the questions right, like, I think I'm about to get evicted, but I haven't had heat for 3 months, what can I do? They still probably need help asking the right question to I'm asking GPT-5 and Gemini sophisticated legal questions because I want to see the difference in the work that they do. But I've been a lawyer and a judge for a long time. If I didn't have that training, I'm not sure I would know the right questions to ask. So I still think there's like a front end and a back end role for humans. It's just not clear to me why those humans necessarily need to be licensed lawyers for all issues for all people, right? So maybe some combination of this community justice worker groundswell and rethinking the role of technology and UPL and regulation of the practice of law could create some breakthroughs, which would be amazing.
Yeah, very cool. Well, we're grateful to IALS for the report and for moving the conversation forward. And many thanks to you, Bridget, for raising the bar on the AI ahas and on everything else that we do, and for being so generous with your time today. And I think that's a wrap for our conversation today. So, anything else before we call it a day?
I don't think so, but great to see you and talk to you as always. I always learn whenever I get to talk to you.
Well, same to you, Bridget. And thank you to everybody out there for joining us. And we will see you on the next episode of AI and the Future of Law. Until then, stay well.